Thanks very much, Mr. Chairman, and I know this side of the aisle very much appreciates your comments, so thank you. Today, the committee, as you said, is voting on 46 nominees, 44 judicial nominees, as well as William Barr's nomination to be Attorney General of the United States. I'd like to first address Mr. Barr's nomination. As I have said from the outset, the question for the Senate is whether he is the right person for the job at this time. Special Counsel Mueller is in the midst of an investigation into Russian interference in the 2016 election, whether any U.S. persons were engaged in those efforts, and whether there has been attempts to obstruct justice. That investigation includes both criminal and counterterrorism allegations. It has already led to 37 indictments and guilty pleas, including 6 of the president's former advisors. This is also expanded to include investigations and cases in the Southern District of New York, the Eastern District of Virginia, and the District of Columbia's U.S. Attorney's Office. Special Counsel Mueller must be allowed to finish, and other Trump-related investigations and cases must also proceed without interference, with the underlying facts and evidence shared with the Congress and with the American people. This report must be made public. At Mr. Barr's hearing, I asked several questions about the investigation and the report that Mueller is expected to produce, and so did a lot of other senators. I also sent 2 letters following the hearing asking for Mr. Barr's commitment to provide the report to Congress and not interfere with the investigations. Unfortunately, Mr. Barr would not commit to providing Special Counsel Mueller's findings and the final report to the Congress, nor did he answer my letters. This is particularly concerning, as nothing in existing law or regulations prevents the Attorney General from sharing the report. In fact, as part of our oversight responsibilities, Congress routinely requests and receives confidential information to closed investigations. And in the most recent example, Congress asked for and received investigative information, including transcripts of FBI interviews of witnesses involved in the examination of Secretary Clinton's email. The president routinely tweeted, and Republicans demanded all information be turned over, and it was. The president has said that release on Mueller's report will be totally up to the Attorney General. This clearly means that this nominee, to me at least, is reluctant to state a position, and that's troubling at the very least. Mr. Barr wrote an extensive, single-spaced, 19-page memorandum 5 months before being named to this post. He provided great detail and legal arguments for his view of the president's absolute authority. Under his theory, the president is above the law in most respects. For example, Mr. Barr argued that conflict of interest laws cannot apply to the president because they, quote, would impermissibly disempower the president from overseeing matters, including those in which he has a personal stake. Mr. Barr concluded that the Constitution, quote, places no limit on the president's authority to act on matters which concern him or his own conduct, end quote. That's page 11. And he argued that certain presidential actions, including firing FBI Director James Comey or telling the FBI to go easy on Michael Flynn, can never be obstruction of justice because the statute does not explicitly name the president. That's the memo at page 10. This is a stunning legal argument. Also, it was given to the White House prior to his appointment. Taken to its natural conclusion, None of our laws would apply to the president unless the president is explicitly named. In fact, when combined with the view that the president can interfere with investigations into his own conduct or that impact his personal interests, the only conclusion is that the president is above the law. That's stunning. To argue that the president has no check on his authority flies in the face of our constitutional principles of checks and balances. But the arguments made in Barr's memo go even farther, to assert that presidents have no limits on their power to insert themselves in law enforcement matters, even those involving their personal interests. And that can't be acceptable to any of us. I believe the memo is disqualifying. I'm also concerned about Mr. Barr's evasiveness when asked about Roe v. Wade. To many women in this country is all important. Specifically, when asked whether he still believes that Roe should be overturned, Mr. Barr would not provide an answer and instead spoke to past practices of the department. And when Mr. Barr was asked, would you defend Roe if it were challenged, he replied, and I quote, I mean, usually the way this would come up would be a state regulation of some sort and whether it's permissible under Roe v. Wade. And I would hope that the Solicitor General would make whatever arguments are necessary to address that, end quote. Bottom line, he did not commit to defending Roe or to fighting state efforts to restrict a woman's constitutional right to choose. In addition, Mr. Barr was not willing to distance himself from the president's harsh immigration policies, including the president's threats to nullify the long-accepted constitutional guarantee of citizenship to anyone born on U.S. soil. When asked about this specific proposal, Mr. Barr refused to agree that the 14th Amendment guarantees citizenship to those born in the United States. I personally find this very troublesome, especially given the plain language of the Constitution. I also asked Mr. Barr about legal prohibitions on torture and his comment that, and I quote, under the laws of war, absent a treaty, there is nothing wrong with coercive interrogation, applying pain, discomfort, and other things to make people talk, so long as it doesn't cross the line and involve the gratuitous barbarity involved in torture, end quote. This statement was made despite the existence of a Geneva Conventions and the United Nations Convention Against Torture. And when pressed, Mr. Barr would not affirm the well-established position that waterboarding is torture. Thanks to Senator McCain, I was his co-sponsor, the law now confines all interrogation to the points laid out in the Army Field Manual. Now for comments on our blue slip tradition. Unfortunately, Mr. Chairman, and I wished I had a chance to talk to you about this earlier, we are now seeing a departure from this tradition. Today, this committee is voting on 4 circuit court nominees who lack support from home state senators. This is really unfortunate, and it's brand new. And we're proceeding with these 4 nominations despite the lack of 6 blue slips. I would urge this committee to reconsider. We've seen firsthand what happens when blue slips are honored. For instance, President Obama worked with Georgia's 2 Republican senators, Saxby Chambliss and Johnny Isakson, to reach an agreement on 2 nominees to the 11th Circuit, including Julie Carnes, who was recommended by the 2 senators. And during the Trump administration, when the White House has worked with Democrats to identify district court nominees, consensus nominees have been identified and confirmed quickly. as was done in Pennsylvania with Senator Casey. As Senator Strom Thurmond argued to then chairman of this committee, Ted Kennedy, in 1979, this is a quote, "This is my 25th year in the Senate. Ever since I've been here, I was told by senators who've been here a long time before I had the custom before I heard the custom, was that if any senator failed to return a blue slip, a nominee would not be considered by the Judiciary Committee." Senator Thurmond went on to say, and I quote, "I do not favor this committee running roughshod over any one senator from any one state. I hope this does not begin to happen today." Thank you, Mr. Chairman.